A recent Chronicle article highlighted the diversion rate has gone up 20% and his conviction rate has declined by 20%. Isn't diversion a good thing? Isn't that something that we want uh, for our system to be a little bit more um, focused on restorative justice and things like that?
Yeah, and that's a very fair question. It's something that uh, deserves attention. And so that is one of the things that I've been mentioning when I said what's happening on the back end should be more of our focus. And what we know from Chesa's own data that he supplied to the Chronicle, his diversion rates have soared, right, up by 20%. What most people don't know is there's sort of multiple tracks that you can go on to avoid prison. There's not just one. Diversion isn't the only one. When we're looking at alternatives to incarceration, we already have a set of collaborative courts, which are courts that are designed and created to address sort of those root causes of crime that Chesa talks about, that were formed by his predecessors, Kamala Harris, many of them by George Gascon. Those courts include drug court, mental health court. It's called a behavioral health court. We have veterans court, which is a court strictly for people who have, done service for this country, to access the benefits that you can as a veteran to get services. We have young adult court, which is something that was created by George Gascon for offenders who are 18 to 25. They receive a case manager. And all of these courts have a specific judge that is, so that they're only dealing with one judge. That judge gets to know them, gets to know their case. Young adult court gives them a case manager. They receive vocational training. They receive help with getting their GED if they don't have it, counseling services, a number of things to sort of get their lives back on track and in the trajectory that we all would hope that it would go. And the way those courts often work is, in order to enter them, you enter into a plea. Most often, you enter into some type of plea to a charge. And the understanding is that if you follow through and complete the program, that you will be able to then withdraw the plea to that charge and enter a plea to a less serious charge, or in some cases, earn your dismissal. Diversion is something very different. Diversion is it's kind of a watered down version of that. You have to sometimes go to just some classes, be it anger management classes, Narcotics Anonymous classes, parenting classes is one of them for parental care diversion. And if you do sort of these 12 classes or how many ever they assign you, your case is dismissed. It doesn't require you to enter a plea at the outset. You just are sent there, and hopefully you complete those classes, and that's your dismissal. Historically,
and if you don't complete the classes, what happens?
Well, so that's the key here. So historically, diversion was reserved for low-level offenses. It was not a place for violent offenders or very, very chronic offenders. It was for those who, were kind of new to the system maybe, and didn't have a long criminal history. And we wanted to keep them sort of as a full citizen in society, meaning with all the abilities to do all the things that we want you to do in society. And so we gave you the opportunity to not end up with a conviction on your record, or you've committed a crime that's very, very low level. And again, want to give you the opportunity not to have that on your record. But now what we are seeing is an abuse of all of these programs, particularly of diversion. We are now seeing violent offenders being sent to diversion. Diversion is something that actually has structure and rules. You're actually not eligible for it if you've committed a violent offense. So what we're seeing happen is, and I can tell you about an example, which is of a man who committed an armed carjacking. And what happened was he was charged with felony carjacking and felony robbery, which are both serious and violent felonies. They're not eligible for diversion. But Chesa's office dismissed those charges and added new charges of grand theft, which is just your average theft of something over $950, making this person eligible for diversion, and sent the person to diversion. that is not the way that diversion should work. We are also seeing people not complete the programs, not complete classes. They are, because of course you are out of custody while you're going through diversion, people picking up multiple new cases and not being sort of taken out of diversion, but being allowed to remain despite now having 2, 3, 4, even 5 additional cases, clearly demonstrating that they are not willing to take advantage of this opportunity, right? And the final thing is, there's no protection in diversion for the DA's office and for the community. Chesa talked about how, in the interview with the Standard, about how, well, you know, if somebody doesn't complete diversion, we can always just move forward with the criminal case later on.
Exactly.
But
Yeah.
as a prosecutor, what we are always thinking about is access to our witnesses, to our victims. And if somebody has been allowed to flounder in diversion for a year, sometimes even more, before the DA's office says that's enough, and we haven't required them to enter a plea on the front end, we are now a year or more later trying to build a case to go to court with, after so much time has passed that victims have become upset and oftentimes unwilling to move forward and help the case. Witnesses have moved away. We've lost track of their phone numbers because they've changed. It's very difficult to put together a case for a trial a year or more later, when you haven't been in touch with these people for that full length of time. And so it's very unrealistic to believe that we can just simply snap our fingers and move forward with a criminal case when we've been doing nothing with it for some long period of time. And so that's why initially we have always engaged in having the protection of having the person enter a plea at the outset, especially in the kind of more serious cases, so that we didn't have that problem. If they didn't complete the program, they already had entered their plea of guilty and they knew what sort of consequence they were facing if they didn't complete it.
So this is something that I was looking at in the Standard interview myself, that he was talking about, and I'd love to ask him, but again, he's the empty chair in the corner up there. We don't have him here, so I can't ask him. But it sounded like he was saying, you know, he's pushing things into diversion. That's so much better, which of course, I think everybody wants a better outcomes from our system and for people to go on to lead productive lives, and incarceration isn't always the right answer. But it sounded like what he was saying, that, you know, people go into diversion and very quickly, if there's a problem, they take them out of diversion and they charge them with the original crime. And it sounds like that's not actually really happening. And that is much easier to say, but it actually is much harder to do if you haven't charged for the crime on the front end.
Yes. And so what I've tried to explain to people is that Chesa's rhetoric depends upon the listeners not truly understanding the system, right? For the average person, you would say, yeah, absolutely. Okay, that's the safeguard. If they don't complete it, then you just move forward with the case. But as prosecutors, we know that that's actually very, very difficult and rarely ever happens when you've allowed that much time to elapse. And so what's happening is when we have compiled public records in a lot of these cases, and what we're seeing is, like I said, despite people picking up new offenses, despite people not showing up multiple times and completing these programs, they're still being given the dismissals, because diversion results in a dismissal. You complete these parenting classes, you get a dismiss, your case is dismissed. It goes away forever like it never happened. They're still being given the benefit of that outcome, despite the fact that they are failing at the program, at actually doing these classes.
And they commit another offense, then they're considered a first-time offender. Is that correct?
If they had no other record, yes. It's as though that prior case never happened.